Greetings and welcome to another edition of Between the Lines. I'm your host, Karanja Jackson. In our previous edition, we looked at access to justice and the various barriers that are there that prevent the common mwananchi in accessing justice here in Kenya. And today, we look at how ICT can be used to access justice here in Kenya. In studio again, we have Mr. Kioko Wakivandi, who is the Media Relations Officer with the Faculty of Legal Aid Project, Egerton University, and lawyer Steve Biko, who has been helping us understand what access to justice is here in Kenya and what it means to be denied access to justice in Kenya. Keep sending your questions and your comments, and we shall be sampling them as we continue. Gentlemen, karibuni sana. And we just pick up maybe from where we stopped the previous time.
Yes.
We were discussing about the various barriers that are there that prevent the local mwananchi or the general public from accessing justice. We looked at society barriers, things like discrimination of women, minority groups, poverty that continues to become a big impediment in accessing justice in our republic. And today we are looking at ICT and how it can help us access justice. Now, Mr. Kioko, if I may ask, by ICT, to which forms of media do we relate?
Yeah, basically when we are looking at ICT, we are talking about computer mediated forms of communication, right? What we also refer to as digital, okay? And if you look at it in a broad way, then a while back there was even the launching of what was referred to as within the circles of governance, what was referred to as governance 2.0, and which related to also the launch of what we refer to as Web 2.0. And Web 2.0 in technology spheres, when you talk about Web 2.0, then we are talking about that kind of communication in which you know, there are certain advancement in the way we use, you know, computers and technology to communicate with audiences and so on and so forth. Of course, what comes then with Web 2.0 and therefore even governance 2.0 is that there is fastness, you know, there's very little time lapse when it comes to delivery of certain things. And therefore then when you want to look at the impact of ICT in terms of delivery of justice, then you are talking about the way information communication technology, the way digital technologies are being applied in the delivery of justice. There are quite a number of advantages in that. There is efficiency. There is also some kind of accountability. There's some kind of transparency. Remember what we always say, that justice delayed is justice denied, right? So then we are even talking about the fact that with the application of digital technologies within the spheres of justice, we expect that files will not get lost, okay? Like we always say, you know, a physical file has been lost, yes. Okay? Then there is also that aspect of the easiness with which we will even access those files, because if that data has been keyed in, okay, at a certain digital archive, it is easy for someone can even access it wherever they are. It does not mean that you have to go to the registry for you to access that kind of, you know, that file. In this era of COVID, we saw that Judiciary has played a key role in delivering rulings and judgments, okay? Making sure that cases don't stall just because we cannot access courts physically, okay? So that is exactly what we mean when we talk about the impact of ICT in the delivery of justice, because initially then it will mean everything we do is physical. Filing of cases is physical. Meeting with this lawyer is physical, and so on and so forth. So there are quite a number of things we are doing today, courtesy of information communication technology, which are advancing technology. Of course, everything has its pros and cons. So again, there are also certain things that are happening which are also delaying the delivery of justice. Okay.
And maybe we will be looking at, we shall be sampling this as we continue. Wakili, would you mind or give us an overview of how it has been now in relations to the use of ICT, especially during this the pandemic time, where you members of the court have been asked to use Zoom and other ICT related mechanisms to argue out cases and such a view. How has it been for you, Wakili?
Well, for those of us who are fairly trained in ICT technology and have had the advantage of growing up in a computer era or generation, have had the benefit of easier use and a quick adaptation to this new reality that has struck home. Previously, cases were heard physically in court, which is now toppled over by the pandemic itself, leading to a new order which we have to accept, and we have accepted is a new reality going forward. It is practical with regards to mentions. It is also very practical and efficient with regards to judgments and rulings, because those are momentary and instantaneous events in courts. However, there's tremendous difficulty still with hearings, and most significantly, hearings involving huge amounts of documents or quite solid type of evidence. Like take, for instance, you're dealing with the murder case, where you need to use exhibits being adduced before court, adduction of murder weapons, or offenses that have been perpetrated using some weaponry, still poses challenges, because you cannot reduce such weapons into soft material to be loaded into a medium. Even if it is Zoom, there is also the other challenge of transition, a transitory challenge where you and I here can physically touch what we have or probably interact with certain documents. But if it is a judge on the other end, it will need a lot of efficient IT platform to have a quicker transition. Yet we still have a challenge of electricity is still a problem. Energy reserves like generators are still a problem. And sometimes you find that you're not the only one to be heard. So there is what we could call efficiency still a challenge. There is also the challenge of what I can call, if you need a translator, for instance, and the witness is on the other end, where language is a barrier. Take, for instance, where a witness or a party to a proceeding cannot grasp proficiently in English or can't converse adequately in Swahili, you'll find that you'll need a translator. So meaning would be lost in the translation. The other problem with the ICT forum is that putting certain points with so much precise clarity is a problem still. The way we are conversing here may not be the same when somebody's on the other end, so that clarity is lost in the electronic medium via which we are doing it. Then when there are breaks in the process, for instance, through network problems, you hear people making jokes about, Your Honor, can you hear me? Your Lordship, can you hear me? Or on the other end, the judge is saying, I cannot hear you, I've lost you. Such breaks normally lead to a lot of difficulties, but we have tried. With the ICT system in court, they have had decent officers.
They have tried.
They have really tried. Beyond expectations, I think they have done much. The only difficulty is now with filing, because, again, you need to scan a lot of documents. The ones that you're now trying to preserve and put into soft copy becomes a problem scanning, because the court is overwhelmed. We don't have enough human resource in court compared to the feeding system. Law firms and even individuals feed so much into the system, but we have just a number of ICT officers doing the printing and having to avail it to judges. So ICT is a good thing, but we still have a lot of strides, giant steps to make going forward. We've just started. We do hope that going forward we'll make progress in this diverse field and to make it more efficient and proficient to all.
And how has it been now? I do understand on the courtroom,
yes,
maybe you have a camera or a computer that is fitted with a camera. What about the suspects?
That's now where we have a problem again. You know, we have to get them through the prisons department, because they can no longer be brought to court. The others, those who have not been detained, are taken to the police stations, or the courts have tried to regulate in consonance and compliance with the Ministry of Health guidelines. We've had a state where the numbers are restricted to specifically those who are supposed to be in that court. That is about 6 for smaller courts and 12 for the larger courts. That way you restrict only the essential parties to the proceedings. That is media, 1 or 2 persons from the media. You will probably have the prosecutor in court. You'll have the judge presiding at the trial court. You'll have the advocate and probably the accused in some cases where they are not under detention, like the ones who are out on bond. But the ones who are not out on bond, presently in detention, they are heard from either committee, here London, the prisons here in Nakuru. The prisons department are coordinating with the court so that they are accessed from wherever they are, to prevent the spread and also to bar mixing up with them coming to court and going back to prison, ending up risking the lives of those in prison. So all those precautionary steps have been taken. We can access them. I actually did one hearing last week at community prisons from Nakuru. So it's working, but again, you have to be on the line waiting for the specific judge, and you have to abandon all things you're doing elsewhere to particularly concentrate on that.
Speaking of challenges,
yes,
there is some conviction,
yes,
when I am maybe giving a defense about myself,
yes,
while in person,
yes,
where I can use maybe my facial expression,
yes,
my body, my voice, my tonal voice,
yes,
in convincing the judge,
yes,
that I am actually innocent.
Yes.
Do you think now that this ICT empowered way of passing judgment may hinder that?
In terms of judgments, you know, a judgment is the outcome of a case, so a judgment may not be hindered much. A judgment is just the outcome. What might come in is the mitigation, and where you are offering your last prayers, like what you saw with Waluku and Wahungu being done at the tail end, where you are being sentenced and you're asking the court to reduce the potency of what you're doing. But that you can easily do. Rulings, those are basic declarations of the court on short terms. The difficulties with the hearing, where you need character evidence, for instance. There is also the threat of coaching. For instance, I'm representing you, Jackson, against Kyoko, and I'm seated somewhere with you in my office doing the hearing. Chances are very high that I could even be writing to you notes if we want to manipulate the system. Kenya is a fairly rotten place. And if it is the prosecutor who wants to build up a strong case against you probably, and they had a weak case, they would easily manipulate from their end. So that's why we've done beams, for instance, in court. They sit inside the chamber and everybody's within sight of the screen. So that mitigates or reduces the impact of manipulation or wrong. You know, people take advantage of situations. Now, there is the other problem with character evidence. You cannot really evaluate character of a person on a screen. On screens, we have our best manners. You've seen instances where Zoom sessions have turned wrong or have gone south.
Yes.
So on TV, people tend to have their best manners and they tend to regulate themselves because the environment is controlled, as opposed to where probably emotions would come in naturally to determine truth and all that. We use a lot of indices to test a truth and to test the veracity of a case. That would be a challenge now, and the question of coaching also comes in. When I'm seated somewhere with my witness in the office, you don't know whether I could be having a brilliant law student next to me trying to tutor or give answers or specifically train a witness to say certain things in that setup. So that's why it's still a challenge, but we hopefully hope that we'll all uphold the oath and also ensure that the truth comes out. But going forward, maybe standard computers will probably have, instead of using phones, we could use webcams and all those in the offices and or wherever we are.
Okay, Mr. Kioko,
Yes.
allow me to come to you. And now we're talking about ICT and its role in accessing justice. How can ICT be used as a tool to foster access of justice in Kenya?
I think we just go back to what I had alluded to at the start of the program, that one of the things then we need to do is, for instance, and actually if you look at the current judiciary we have, you know, the archiving and so on, it is very efficient these days. Sometimes, and even from where I sit, even today when we are training journalists on how to even access certain judgments and so on and so forth, we just tell them the most important thing would be if you know just the case number or something, or even where it was had and so on. These days it is so easy to even know, you know, for instance, I am in Nakuru and I want to know the cases that will be had in Mombasa. The only thing I just need to do is to go to the website. So then we are saying it's important for us to have proper archiving mechanisms and our repositories, right? Make them so efficient that they are just a one button or one click away for you to access whatever information you want. Okay. Yeah, I think for me that is, you know, very important. And then of course try to bring on board everyone. One of the reasons why most people don't have, you know, most of this information is that, first of all, they don't even know how to access. There are people who don't even know that there are certain services that have been made digital. They have been digitalized, you know, by judiciary and so on and so forth. So it's going to be very important for us, as you know, the days go by, to keep on invoking you know, the law on access to information, which requires that, first of all, sensitize people. Okay, the lawyers may know because they interact with the judiciary on a daily basis, but what about these other people? Okay, what about these other people, the lay people, the you and yes, the you and me?
Yes.
Do they understand that these services are actually, you know, digital, and so on and so forth? Of course, there are other courts that to date they are still miles and miles away from this you know, digital discourse and so on and so forth. So even those ones, now we need to empower them. Okay, it's not, you know, like, we are not saying that you can access information about all the courts in the country. We will be lying if we say that. But for those that are already, you know, they have been empowered to do that, and I think one of them is actually Nakuru because of its stature and so on. Let us make sure that there are no loopholes. Let's do our best to maximize on the opportunities that we have. And for those courts that need to be capacity built, then let us capacity build. It's just, you know, a matter of just having some kind of a proper MIS, management information systems. I don't know if and perhaps Biko can tell us whether judiciary has an MIS which is specifically for the judiciary. You know, like you know, at the university, for instance, we have we have an MIS which is used, you know, for matters,
Yes.
academics and so on. Do we
Yes.
have one for the judiciary?
It is. In fact, in most of the sections, you know, records have been kept for a long while, but they were in the text form before, but they have now been reduced into soft copies because this thing just came so fast that nobody ever anticipated its relevance. It forced people to really rethink the entire information storage system and management to an extent that now we, for instance, have judgments, all judgments in the country, from the High Court and above, and of prominence, are reported to what we call the electronic Kenya law report system. So that if you want a case relating to probate, let's say a succession dispute, you'll just key in Jackson, Karanja versus Kioko, and it comes out. Or you just key in a case like, you are probably doing your own research. You have a similar case like this, and you want to get such information. You key into the EKLR, that is online Kenya law reporting. A case that is determined today is then fed into that system today. With that, then we have a repository of all the cases in the country, which would otherwise be stored in books on shelves in offices. Then only law firms which had money and status and capacity would afford such books because those books were quite expensive. Right now, all you need is internet and you are good to go. The other thing is that ICT has also enabled information collection. That is in terms of evidence. You can now record the proceedings on Zoom. What we were missing on a digitized platform, like it was suggested that we should have the recording systems in court. But now the Zoom system can record all that, even the Teams. All the digital platforms have a recording mechanism by which we then record this information. So instead of waiting to do shorthand, you can do shorthand, of course, but you see court proceedings have to be recorded as they are verbatim. So it means that precision and accuracy has been enhanced on the digital platform, because that which I speak will then be recorded straight away as it is spoken, compared to a recording where you trust a court to correctly and articulately record what you've spoken. Most of the appeals that we see, usually at the Court of Appeal, some arise out of inaccurate recording of proceedings. So a digital platform enhances accuracy of proceedings, so that when you are doing a hearing, take for instance in an election petition which starts from 8 a.m. to 5 p.m. or in a murder case that goes on a whole day. You know, judges are human beings like you and I.
Yes.
Even advocates, we do record our own proceedings. So that which I may have missed to record will then have been reflected in the digital platform. So it enhances accuracy. It enhances speed of collection of information. It also enhances what we could call historical perception. You can always get this information, even 20 years' time. Certain proceedings may be discarded with time, but these ones now are on electronic platform. So we'd have them recorded for comparison's sake and for even training of law students and or even the society, like what we have been doing with Kioko in the market centers. You can give them in forms of videos, like the programs that are being shown on TV. We can use that platform to train younger students even at high school level. At high school level, at the debating forum, we can use it as a platform. We can now go back to the presidential petitions that were done in 2013 and the ones that were done in 2017 to capture those records of proceedings, to enable the learners pick what is relevant to them, and to also teach them how to persuade courts and how to make decent presentations. You can see it even in American law movies and all those judicial movies that we see. They teach people a lot of what can be done and how it can be done. Courtroom sessions can then be presented forward. So in terms of training, it enhances the scope of training compared to a courtroom where courts record without a digitized framework. It only stays there, and whoever was present there then is the only one to get it. Usually then we would get it through the media, but the media would only capture snippets of what they would require compared to a full platform on Zoom or sessions. And if it's on Zoom, so many people can join in without necessarily being in court. You can be hearing the same from Nairobi and all that. So it's a platform that is beneficial to all. And that has facilitated dispersal and spread of information. Thank you.
Impressive. The show is Between the Lines. We are discussing the role of ICT in access of justice here in Kenya. We'll take a short breather. We'll be right back.
Thank you.
Welcome back. The show is Between the Lines. I'm your host, Karanja Jackson. We are discussing the role of ICT in access to justice here in Kenya, a program made possible by the auspicious donations of the Faculty of Law Legal Aid Project, Egerton University. And in studio today we have Mr. Kioko Kivandi, who is the media relations of FOLLAP, as well as Mr. Steve Biko, who is a lawyer based here in Nakuru. Keep sending in your questions. We shall continue sampling them as we continue. Now, Mr. Kioko,
yes.
Allow me to come to you and ask you. Now, we have highlighted a few advantages or merits of having ICT in access to justice. What do you think are some of the demerits that ICT comes with in the push for justice or access to justice?
Of course, the demerits will come with, because this is just a computer-mediated platform for the delivery of justice, okay? And sometimes it takes us back to that question of, there's a debate that a certain communication scholar once initiated a while back when he was saying that, you know, the medium is the message. That discussion by that guy called Marshall McLuhan, when he was saying that a message is as important as the platform on which it is delivered, right? So even we can still use that conceptualization even on matters ICT and justice, and say that the medium is the justice, and that the medium on which, the platform on which a certain mode of justice is delivered is as important as that piece of justice, you know, at the end of the day. So much so that if, for instance, you are using a local mechanism to deliver justice to someone, then at the end of the day, the amount of satisfaction they will get from that, you know, from whatever agreement will be arrived at, will be as important as the whole process. So that then if the process is interfered with, then even at the end of the day, okay, then we will have a piece of justice which is also interfered with and therefore is not satisfying. So much so that then when we are talking about the demerits of ICT when it comes to the delivery of justice, then we're just looking at how we are looking at the inadequacies of ICT to solve quite a number of our problems. And one of them, of course, will be the fact that sometimes you have this aspiration to open up your space so much to so many actors. And because of that, then some people come in to interfere. We have hackers and so on and so forth who take advantage of the technical know-how they have with matters ICT. And sometimes you may end up getting certain visitors who or certain people who should not have eavesdropped into your conversations, okay? In as much as we want to say that this thing is being delivered in an open court, right? Yes, the principle of justice is that everything should be transparent and so on and so forth, right? And that's why we even refer to certain court sessions as open court sessions, right? So in as much as ICT may be opening up the court space, sometimes it is not just open to everyone, okay? And there are certain cases then people will take advantage of that. We have also talked about that aspect of the fact that, and last week we also talked about it when we say, development in this country followed the railway line, okay? And because of that, then even the development of the judicial system in the country, again, so many things, especially structural issues in the country, again followed the railway line. Even the development of ICT in this country, ICT infrastructure is also following that kind of trajectory. So you realize that in as much as we have certain courts that are so much advanced in terms of use of ICT, there are other courts that do not really know what ICT is and use of ICT is, okay? The other day, I think it is this court in Milimani, okay? Yes. You just see it projected on TV, and the clerk has a computer over there, and so on and so forth, right? It doesn't happen like that in quite a number of places, even if we are not going to mention those places. So that in itself, the inequality in access to ICT services, okay? Certain regions experienced internet for the first time during this COVID pandemic because of the looms. Are they called looms?
Balloons.
Yes.
Yeah, okay. The loons that, the government distributed all over, certain our airspace and so on and so forth. Yeah. So that in itself is a demerit. The fact that we want to have equity on matters access to justice with respect to use of ICT, okay? But there is inequality when it comes to ICT infrastructure. Yeah.
Okay. And maybe allow me to ask you, Mr. Kyoko. Now, in your own, let's put Mr. Biko aside for a minute, and let's think about this, because now both of us are on this other side of the law.
Communication or
from a communication perspective.
Yes.
There is some weight to the matter when you're talking to someone face to face than when it's mediated. Do you see the challenge that I'm seeing, that I may not be able to convince the judge that I was actually not there when that thing happened?
And that's why I actually quoted Marshall McLuhan and that statement of the medium is the message, okay? To the extent that, and I explain that sometimes the message is as important as the medium on which it is communicated. That's from a communication point of view. And I'm saying if we could conceptualize again use of ICT with respect to access to justice from that point of Marshall McLuhan and say that the medium is the justice. Okay? So much so that if we are using a computer-mediated judicial process, because the moment we use computer-mediated will just mean that there is use of ICT and computers and so on and so forth. Okay? That the accused, the parties, are using a computer-mediated forms to communicate to one another. That in itself brings in certain communication challenges, because even in court, when they are litigating, that is just a form, it's a face-to-face communication. And computer-mediated communication has its own challenges. Okay, it has its own challenges as compared to interpersonal communication, which is face to face. Yeah.
And Mr. Biko, allow me to come to you.
Yes.
Now, in the corridors of justice,
Yes.
And we're living in a very unprecedented time, and a lot of things have changed. What has changed, apart from the use of ICT? What else has the pandemic brought as a new normal in the justice corridors?
One, it has prohibited movements, basic movements that you had with the police arresting and arraigning you immediately. That is almost impossible because you need to get a digital platform. Previously, you'd rush to court. In fact, before, you'd have an emergency and you'd be heard almost immediately for the certificates of urgencies. Like, let's say auctioneers were to land at your door today, you would easily run to a lawyer's office and get documents drafted and have a lawyer as early as tomorrow in court. That is almost impossible right now because the documents have to be scanned, uploaded into the system, received on the other end, receipted, assessed on a digital platform, reversed to you in the office for the amounts that you're supposed to pay. Then it means they approve, then you forward the documents. Once you forward the documents back to court, they also have to download them, print, bind them, and present them before the judge. That was a process that was already done previously by the clerks in the law firms or the students or the secretaries. They were doing it. So that my job would be to just go to court and argue the case. There was a lot of role plays back then, but now that role has been shifted to the court. So we have eaten into a judicial labor and human resource so much that they are thinly spread out and emaciated in terms of their services and efficiency. Secondly, there is also the problem of emergencies. Like recently, we saw Murua Dikere MP Ngeno being arrested in Narok and being brought to Nakuru. He had to stay there for about 3-4 days.
Yes.
Even Oscar Sudi stayed there for almost a week. Those are things that would not happen before because you'd then be taken to court, and if there was lethargy on the part of the police to bring you to court, your advocate would easily plead or demand that you be arraigned in court through the relevant hourly time limits of 24 hours for misdemeanors, those are small offenses, and 48 hours for capital offenses. Right now, even reasonably, how would you force the police to avail you before court within the next 48 hours when in all practicalities it would be impossible in view of the IT platforms that are required that may not be available? Take, for instance, a murder occurring in Kilgoris, God forbid. Before you're availed in court, and a murder case would be tried at the High Court. Kilgoris does not have a High Court. It means you have to be taken to a Narok High Court, or previously you had to be brought to Nakuru. See, all those are challenges that we're now facing. Or sampling up evidence, for instance, in traffic cases, where you have to deal with these matters as of urgency. Somebody has been arrested at Salga while speeding. He's been flagged down by the police. Before he's arraigned in court on an ICT platform, that would take time compared to before, where you'd just be lumped into court, you plead guilty or not, and you move on. The other one is mobile courts. We used to have mobile courts. They're almost impossible to conduct now. Those remote areas like in, let's say, Dol, that is in Laikipia. We have mobile courts in Nginyang. We have mobile courts in places like in Turkana, Nginyang. We have Tangle Bay in Baringo. Those areas are normally traveled by judges to reach those people who could not be facilitated to come to court. That is impossible now with the ICT platforms and the COVID pandemic coming in. If you are arrested and you've been given bail and bond, and your persons or persons representing you, your lawyers or your family have come to stand in as surety, what happens to you? It means that they probably will be having the money, but processing up that money so that you don't go into prison while awaiting that takes time. So you'd easily go in, even if you have the money. That's why you saw, for instance, the Oscar Sudi case. You had to stay in for one more day before that money would be processed. Or if it's talk of a surety in terms of title deed, a title deed is probably your ancestral or family land in, let's say, in Kisumu, or Nairobi, or let's say in Murang'a and you are here in Nakuru. Let's say in Mombasa, Mazera, somewhere in Kilifi, and you are here. By the time they process the title deed and do searches, it will take 2 to 3, 4 days because a valuation has to be done. The lands registry, which is another pillar of valuation, has now been clamped down. It cannot work as it used to work. We also have things like visitation. You can no longer visit accused persons or persons in remand as you used to do. Before, you'd easily walk to the prisons because the spaces had been opened after the Mudia Wari reforms. So that has now been clamped because you'd easily infect those people. Or if there is a breakout of COVID over there, it would be a danger to everyone. So there are those benefits that we had before, which have been clamped out, or what we call the rights of an accused. There are those that are not practically possible to enforce right now, like visitations, access. Even we lawyers now can no longer just access them unless it is very necessary. We cannot access them almost readily as we used to do because of the health guidelines. Or let's say an accused is sick now in custody or in at the prisons. Getting him out of that place to facilitate his treatment at PGH will follow very complex channels, which were bureaucratic channels, which were not be existing before. So all those poses challenges, and people may end up dying in the process. There are people whose lives have been lost because of those challenges that we're having.
And now I'm just looking at this and just thinking of how sad it is, especially when you will be delayed justice on the mere fact that maybe there is a backlog of other cases that have to be listened to before we get to yours. But now I'm thinking, we are like going back to normal. We had a Bomas delegation today that had thousands of people there. We are witnessing politicians having roadside campaigns and whatnot. Don't you think it's time like we just go back to court? Because after all, it's being done elsewhere.
All of us have been praying for that. You remember the Law Society president, Nelson Harvey, at some point had to fight for lawyers to literally go back to court. And it was not for the lawyers alone. It was for everyone else in terms of what we were facing then was certain benefits would not accrue to the right to legal representation is integral in the ordinary process of a court case or in criminal matters or civil. It facilitates, it is facilitative. So that if you cannot go to court, then it means also so much would be lost. For instance, judges would take time before they get files physically, probably if they're not here. The judges who are over 55 or 58 years, accessing them would be a problem. You depend on a clerk in court to do that. Our courts, you realize, had budgetary cuts, so that would basically affect them. Yet on the other side, you're seeing politicians doing their things. So that's just the indiscipline that we've had as a country. It's a deep-seated problem. It's actually absence of ethics in this country. Even all this debate we're having about the BBI and all that, if we just strictly respected what is already available, even by a quarter, I tell you, Jackson, this nation would be so far away into progress and far away into prosperity. But we have a difficult mindset. We have a hard mentality that things should not be done in a certain way because they would benefit certain segments or sections of the society. So that is where we are, but we should actually go back to court with guidelines now and new courts being built like, hey, Nakuru, why not? With courts restricting the numbers. It's more efficient while you are in court compared to being facilitated elsewhere.
Mm-hmm. Now, Mr. Kyoko,
yes.
Do you think, or do we have policies that have been put in place to ensure that the poor and the marginalized are actually not affected or hindered access to justice because of where ICT is prevalent?
Of course, well, that will take us deep into the discussion on, the ICT Act and so on and so forth, and the state of ICT in this country. Of course, and again, also that bigger question of where we are in terms of development, and also developing our communication structures and so on and so forth. Of course, policies are there. The issue would be to what extent are we, utilizing whatever is available. Like Biko just said, that if we only utilized that little that we have, okay? If you were to look at the Constitution, then it will tell you that its aim is to bring equity to everyone. But to date, we still have regions, like I said earlier, that are not as developed as these other areas. We have a region where someone is struggling to look for food. To what extent will they spare money to load bundles and so on, so that then they can enjoy ICT? A while back, a Citizen TV reporter did a story, and it actually won a CNN award, where we were shown a village where if you wanted to make a call, then you would run to a certain hill. Okay, you'd run to a certain hill for you to make that call because of poor network, poor network reception and so on. How many regions in this country actually have poor network reception? A simple way of just making a call. It becomes, really, really difficult. There's so many places really in this country where making a call, even in my home area, some place in Kwale County, okay, it is still difficult for us to make calls to date, okay. There are certain goodies we enjoy in town, and we think the whole nation
would be enjoying them.
the whole country enjoys, right? Yes. Make a trip today and go to East Pokot. Okay, you will realize that you have no. The only way you will only be taking out your phone to look at the time.
It becomes a watch.
Yes, that's when your phone will become a watch. Okay, yes. So why? But if you go to if you go to Treasury, they will start getting you out, or which ministry is responsible for development these days. Initially, we had
presently
devolution.
Devolution.
Initially, we had devolution and so on and so forth, right? They will start getting you out certain, they like saying, policy documents, right? Blueprint, we have this document, and so, and then they will even take you back to, what is the name of that paper? Of the 1960s.
Sessional paper.
Sessional paper, you remember? And then they will tell you, we have made these strides this way, and now we even have an ICT policy to do ABCD. It's not even, sometimes our problems are not a lack of legislative promises and so on. It's a lack of implementation. Okay? We have the policies, but we are not implementing them properly. Okay? Some of these telecommunication companies have chosen not to erect, masts in certain areas based on the market. Okay? And that is what that story by the Citizen journalist, tried to show at that time. Okay, right? So instead of them just looking at the market, what if they looked at it in terms of emergencies? Okay, so much so that then even access to internet becomes a necessity. It becomes a need, right? Imagine what happened in Baragoi that day, that even accessing where the police officers were was in fact, that is one of the reasons why that massacre happened. Okay, because of the poor communication network and so on and so forth. Okay, but the policies are there. Yes. Anyway, we need to keep on improving until we get to where we want to be. Yes.
And no, you've alluded to something that was actually mentioned earlier today at the Bomas unveiling of the BBI about, and it was mentioned actually by the Deputy President in regards to the judiciary.
Yes.
And he alluded to several counties that do not have a high court, alluded to several even sub-counties that did not have even a magistrate's court. And this one is actually what we were discussing last week, about barriers to access of justice here in Kenya, Mr. Biko.
Yes, I noticed and I appreciated that bit in terms of those of us who are not living from the judiciary. But I believe it's beneficial to all. That was, it's good to say thank you for making a word for us when you have a chance to. The judiciary, to be honest, unlike Parliament, which is situated in Nairobi, and unlike the executive whose headquarters is entirely in Nairobi and most of its affiliates are in Nairobi, it is only the judiciary as an arm of government which has got offices spread across the country. But the question is, how diversely spread is this? What is the reach? What is its size on the pie chart? And I do concede it was truthful that indeed courts have not been spread out so wide. But again, I don't take politicians seriously because the Deputy President has been a Deputy President for 7 years and they've known this problem. I don't know why they only suddenly see sense through some of these things when they seem to be on the receiving end. But nevertheless, I do appreciate that gesture. It was a bold one. The other time we were talking about Nyatike when I told you about Justice Maraga going to open a new court over there. There are new courts that have been gazetted previously. There is now a high court in Vihiga. There is a high court. There are courts that have been spread out over the past 1 year by CJ Maraga. And that was in the plan. Though you remember the budgetary cuts. What did these politicians do to enhance the budgetary cuts? You know, sometimes for those of us who have eyes and have got the deep readership to notice and to interrogate them deeply, or we take them for convenience arguments. They're made to suffocate competing or rival interests elsewhere. They're not, in all honesty, made in good gestures because we live in this country. Why should Garissa matters be tried in Nairobi? Why should Mandera matters be tried in Nairobi, yet you have a governor in Mandera? In fact, somebody said recently that you have a guarantee that a ballot box will reach your village, but you have no guarantee that votes and the development you are voting for will get to that village. We also are not mal-governed in this country because of lack of law. We are poorly governed because of lack of will to do so by the political class. Otherwise, if things were just left to, even by our decimal standards, to be at a quarter level, this country would be so far. We'd be so far in this country. We have the resources. We are one of the most gifted countries across the board. So it is true courts have not gotten to places where they're supposed to be. But how would they get there when judges who are supposed to be appointed have not been appointed? I heard the Deputy President allude to more judges being employed. I do appreciate that so much. But what have they done to the ones who have been interviewed and already should be taking their seats? They should tell us why they have not taken their seats and not why some ought to be employed. If some ought to be employed and yet Chinua Achebe says in A Man of the People, if those who are standing have not gotten their share, how about those who are kneeling? So you'd not be agitating for more to be employed when the ones who are supposed to be employed have not gotten their share. So that's what we need to be assertive about. Jackson, who has fought for what he deserves, has not been given what he deserves. How about Kyoko is still in the trenches looking for the same? So let's start with the ones who have been appointed, take over their seats, and then those who are still on the trenches be interviewed, and then they take up. But even if they take up those seats, and you don't provide for the budgets to pay those judges, to pay those prosecutors, to pay the police to investigate, you'll have as many judges and you don't have investigators. You'll have police, you'll have prosecutors, and you don't have the support system which is in the DCI. So that if you don't have a trickle-down effect across the board, then you'll only be what we normally call an ivory tower, seated at the top, but down there is a big problem. Because a judge will only be as efficient as a support system that the judge will have. So that if you don't give the judge enough researchers, lawyers to do for them research, you don't give them enough ICT, you don't give them enough media to cover up certain cases, then you as well as what we call doing a paint job on a white wall.
Remember I told you, when we are conceptualizing justice through the eyes of that communication scholar Marshall McLuhan, from the message is the media, the justice is the media. And that's what he's saying. That if the process of accessing justice, okay, is difficult in itself, then that justice will not be transparent. If the process of arriving at a certain decision was problematic, then the justice that will be delivered will also be problematic. And I think then, in fact, when we are looking at the challenges of accessing justice, one of the major ones will have to be that, budget cuts to the judiciary. Because what we have seen in the past is that the judiciary has faced budget cuts, not because there is no money, but because of that issue of we shall revisit and so on. An outright feeling that the judiciary has not behaved in a certain way, and therefore let us punish them, and so on.
In fact, that is even more surprising because, again, the judiciary is the only arm of government of the three that generates money. The others are only spending. So without the law being in place, then the consolidated fund, we generate fines, we generate penalties, we generate income for the government. Tell me what Parliament generates. They don't generate anything. Does the executive generate anything? They don't. They only benefit from other sources, the taxpayers' money.
And borrowing.
And borrowing. But expenditure, they spend as quick as it comes. So somehow if the judiciary, it was a good gesture by the DP in terms of reinforcing that fact that courts need to be funded. Then demand reciprocal services from the courts after funding them properly. With the little Maraga Azad, you've seen him putting up courts across the country. With the little Azad, you've seen him traveling to non-script stations in this country, and you've seen some work going on. Nakuru has now a new court. Nakuru will soon have a court of appeal. So instead of litigants going to Nyeri, going to Nairobi, or going to Kisumu, they'll be heard from here. That will have, one, reduced costs. That will have, one, reduced the time they are losing in transit. That will have also ensured that cases are cleared and backlog is dealt with.
So as we wrap up, where are we as a country in embracing ICT as a medium of accessing justice here in Kenya?
We are still low, but the uptake is gaining momentum. Even more, I peg it on education. An educated lot is more receptive to technology and appreciate it more in terms of what it is and its value. But those who still need it more are unable to get to this level due to resources and want of the same. inadequate and low-level education for our elderly lot who are still major stakeholders in terms of ownership of property and where most disputes emanate. I'm also aware that persons in the slums have got a mindset pegged towards eking basics of life like food, shelter, and health and Medicare, as opposed to trying to get to utilize such platforms. You also realize that internet penetration in this country is only developing now with the cyber cabling and all that, but that has not gone to certain areas. So that even if it gets to an area, as Kyoko said, development in this country followed the railway line. There are places without the railway line and inevitably roads where they are passed on the way leaves. So you find that entirely the middle class and the more educated lot will appreciate it more, but the proletariats, as opposed to the bourgeoisies, will not enjoy it. The mamambogas who need justice down there will not get it. They will enjoy it only when they are assisted, but that assistance will not come at a free cost. It will come at a heavy cost. So it hinders them accessing justice. And that is where most problem comes from. Most of the people who commit offenses by dint of societal cleavages end up being persons from those poor ends in the society, where more conflicts are, and the easily petty conflicts or the ones that are more savage are also in those low-end areas. Yet those are the places where even getting courtrooms sometimes is difficult, like Kyoko talked about Baragoi. We've talked about petty offenders. Most of them are people who can't even pay fines. So you can't even tell them to use Zoom, for instance, to access court. Between food and bundles, which one will they pick? Food. Between electricity to power their phones and to buy smartphones and to get access to computers and a house or rent today, which one will they choose? So pitted against such essential commodities in the society vis-a-vis what they consider secondary, they will always go for the most essential, which is food, shelter, and clothing, as opposed to trying to, they leave it to fate. Acha kaumane, acha katambe, that is what sometimes they say. Whilst that ends up enslaving the society in terms of a continuous spiral out of societal conflicts and endless squabbles and fights down there, which then makes it difficult for the court system, the judicial system, to absorb those problems.
Okay. Impressive.
Let me add by saying that, the world order has been disrupted by digital technologies. And those who will survive, even in the media industry at the moment, we are talking about the disruption that has been caused by technologies, okay? New media technologies and so on and so forth. For instance, in the media industry, there are certain markets that have been crushed, because of the availability of digital technologies and so on and so forth. The same is happening with the judicial system and so on and so forth. And it's going to happen. Those who will survive are those who will change and conform to the new happenings, right? And especially now, actually, even new, with the COVID-19 pandemic, right? This has also disrupted the world even the more, and I think this should be a challenge to the judiciary. First of all, we also need to note that the kind of lawyers we are training today belong to a certain generation which technologically we refer to as digital natives, people who have been born in a culture of the networked society. They are not like, you can imagine
84-year-old Aminwa, for
84,
instance.
I was actually looking for that name,
yes.
Aminwa, okay? Or even the likes of Nelson Harvey, okay? These ones are digital immigrants. We refer to them as digital immigrants. They were not born in a networked society, but they have been forced to migrate. But the ones we are bringing up today, okay, belong to that generation we refer to as digital natives. So they are going to be more accessible to technologies, and they are going to want to use it the more. So the court of the future is a court that is very, very networked. So it's upon us as a nation to then bring to speed, okay, develop ICT technologies and so on within our court structures, so that then they can meet the new standards that we have all over the world. He talked about Achebe. Achebe also likes talking about a certain bird, which says it will fly without perching because man has learned to shoot without missing.
That is Eneke the bird. It
Yes.
says that
Eneke Tio bird, the bird.
Since man has learned to shoot without missing,
Yes.
the birds have also learned to fly without perching.
Okay.
So that was, as you hunt down, you can never hit the birds in the sky.
Okay. Yeah. So we need to adapt to the new way of doing things, and perhaps then the other thing is also for scholars to study how the judiciary will be adapting to this. You want to look at it from an ICT perspective, that's okay. You want to look at it from a legal perspective, okay. You want to look at it from a communication perspective, it's some kind of an interdisciplinary kind of research and so on and so forth. Okay. Yeah.
Thank you very much.
You want to end? I think it's not fair if we end without also paying tribute to the senior counsel who passed on the other day, just when we
Samba Gitonga,
yes.
We appreciate him. He trained some of us. These platforms are great. Also here in Nakuru, we lost a senior lawyer, former partner to Mirugi Kariuki. He's called Dominic Mukuikimata. Perished, may God rest his soul, as of yesterday. Nzamba Gitonga was the president of the Law Society of Kenya. In 1999, I think Rachel Omamo took over from him, the current Minister for Foreign Affairs, previously Defense. He was also president East African Law Society, and they're the people who generally fought both tooth and nail for the reforms we presently have. And I also note that I was also the chair of the committee of experts that birthed the current constitution, which is now under review for consideration. Even posted his views on Sunday, which were to be posted yesterday, about his analysis on what was not done and what should have been done. But may all their souls rest in peace, as well as the young lawyer who perished in Ukambani, the one who was buried, Makau, who was buried in Wote, and to all other Kenyans. We appreciate everybody else. Every life matters. And wherever we are, we hope that as we develop ICT in the judiciary, it will be expeditious enough in determination of disputes and to make the society a more peaceful and habitable to all. Even as we train students of law at Egerton University through the FOLLAP program, and with your hands in support, let us broaden the scope. Without you, the media, and the fourth estate, we definitely cannot find a heavier and a broader dispersal of this information to the society. I know there are those who are benefiting out of this debate, and we long to find it more diverse, more widespread, and with a heavier dispersal to the need in the society, so that we reach out to everyone. Thank you so much.
Thank you very much. Thank you, Mr. Kioko and Mr. Biko, for finding time to come and share with us. On the first edition, we discussed access to justice, the barriers that are there, and today we have been looking at the role of ICT in access of justice here in Kenya. Remember, this program has been made possible by the Faculty of Law Legal Aid Project, Egerton University. Remember, you can also reach out to them in case of need any legal aid that you may need. You can reach out to them using their toll number, that is 0800 720 448. That is 0800 720 448. Call them, it's free. Get the legal aid that you require. Someone will be listening to you. The show has been Between the Lines. I've been your host, Karanja Jackson. Until next time, stay safe.
Thank you so much.
Thank you.